This call is now being recorded.
Okay. So, hello everyone. Welcome to the session on men's right. And we are doing it in the month of March, which is celebrated as usually as Women's Month. We thought that everybody will speak about women's rights, the women's movement. That will be always there. But we felt the need of speaking about the men's right. I think we felt that that's need of the hour. Okay, so that doesn't mean that it's all the constructed, we are anti-feminist, nothing like that. I would like to start the session with this disclaimer. We would like to speak on a general neutral basis, and also we would like to burst some myths related to the concepts like the law is favoring feminists and all the men are abused because of the feminine laws. And on the other hand, we'll be also stressing on the need of the heart. Like we do need some men-centric laws, not only general neutral, like men-specific laws. So yes, let's get started. And before I get started, let me introduce myself. My name is Advocate Kritika, and I'm here associated with IIPS India, that is Indian Institute of Industrial and Professional Studies, as the master mentor. And today I'll be taking you through this entire journey of the men's right, which is scheduled for about 2 hours. So we can also have a discussion at the end wherein you can put forth your views, put forth your points, and also you can clear your doubts, if any, in this session. So let's get started. Let me share my screen. Okay, yeah, I hope my screen is visible. Okay, so now speaking about the topic for today is workshop on men's right, misconstructed feminism and gender equality. Let me reconstruct this title. What does it speaks about? See, as you can see, it speaks about men's right, followed by misconstructed feminism. That is how feminism is being misunderstood and how it is being misframed for the ugly needs of the few of the sector of society, in addition to this gender equality. So now when we speak of equality or when we speak of rights standard for women, we mean and we state that we want gender equality. So all the people should be treated equally. That is gender wise. Now let us see what are the topics that we are going to cover. The first one is male feticide. Yes, we all of us speak of female feticide, but we never spoke of male feticide. So we have never ever come such word. Now here I would be speaking about this topic as well, followed by education to male employment laws, matrimonial rights, that is more specifically dowry, divorce and maintenance. The next one is how to escape marital, that is legal harassment, child custody, fatherhood laws, adoption, visitation right, precautions to be taken to avoid legal harassment, and few landmark cases wherein the law, it stood against the feminine rights and it said that yes, even the men have rights, even the rights, their right has to be protected, and even that is human rights. So first, male feticide. So this, yes, male feticide is a concern these days. You believe or not, according to the India sex ratio, which was brought in the year 2021, it showed that there are 1,020 females to every 1,000 males. That is, we have 20 females in addition. In additional, that is, the ratio of the female is high. Okay, that is somewhere a good news for all of us, but also a rising concern, because till 2021, the ratio of the male and female was so having so much of gap that the number of the females was very less compared to that of the male. What happened in this period of time, that is, even if you see the ratio of 2020, it is the males that are more, it is not the females that are more. So what happened suddenly? So I think as per the studies and also as per the various articles that were published by the research journalists and others, when this ratio came out, they raised their concern about it. They said that this is one of the booming issue that we will be facing in the upcoming generation. Okay, because all of us know that we are a society and we should have equal ratio of male and female. Now, even if the male ratio goes high, then that is, even if the female ratio goes high, then that is very difficult, right? So we have to ensure that it is going in the good manner and going in the proper ratio. So we propose that yes, there should be, like now we have laws for the female foeticide, abortion and other things. To some extent it has concept of gender neutrality in it, but we feel that, and also we propose that this male foeticide issue has to be addressed in a proper and adequate manner so that it gains good attention. Next, we have male education. Yes, this is one of the concept that is very, very less spoken. So what I feel, what not only me, but what the feeling that is in the general domain is, the male education is not given any priority anywhere, assuming the fact that the males will be provided education because they have to support the family, they have to earn, etc., etc. But we never think that yes, there are many men in the society who are denied of the education to fulfill their family responsibility and who to fulfill their doings, their well-being, and they quit their education. Now recently, like now the trending videos, we might have seen a boy who's who wants to join army and who's working in McD's as well, and he's running 10 kilometers and then he goes cooking, etc., etc., etc. So that we have seen, even the male are deprived of the education. It is not just female. Yes, I do agree, females are deprived of education because of the societal stigma wherever they are, whatever situation they are. But on the similar hand, even the males are denied of the education. They are said, they are forced not to prioritize education. Unfortunately, this topic is not picked up anywhere and is not being spoken, and even to an extent, even male are not vocal about it. They feel that yes, this is my family and I have to prioritize whatever work I get, I do, whatever things I'll earn money. But education is a main, and education is a very, very, very important thing to have a happy life, to have a peaceful life, and also to have a contented life. And so we also tell, and we also would like to highlight this concept that yes, even male education has to be brought into limelight, and even there should be some provisions for male who wants to work and who wants to study simultaneously. And this education as a concept should be gender neutral. Not only female, even the male are deprived of the education. Moving further, employment laws. Yes, though male do not have reservation in the jobs as that of the females, and other benefits, other restrictions in work, like in the Mines Act, we have limitations, we have restrictions for female workers to go below the earth or do that kind of work. Whereas for males, it is not there because they are believed to be masculine and capable of doing it, which is a compliment as well. But on the other hand, we need certain laws which are beneficial for men, like paternity leave. Now, after so much of struggle and after so much of fight, after so much of proposals, after so much of bills, legislations, finally we have got something called as paternity leave. The central government employees, they get 15 days of paternity leave, and the state government, it varies from one state to the another. Whereas even in the private sector, the law has not made something as permanent. It has said that, okay, so it is up to your discretion. If you want to give paternity leave, you can give. If you don't want, you don't give. Okay, but what we propose and what we state is it has to be treated on parallel with that of the maternity leave, and all these private organizations should be said that yes, you have to give the paternity leave. And also it is not a stigma. Many men think that, oh, why do we have to take paternity leave? I'm not going to take. And even if they think of taking, they'll be like, I'll chill out for some time, I'll do that, I'll do this. So that has to be removed from the mind of the people. And even there are many females who feel that no, our husbands is not to take care of the child, we are supposed to do it. Oh, how do I tell him? So that thing, even both as males and as females, I think we have to come out of it and we have to accept that fact. Yes, he is the father and he is bound to do it. Next, gender neutral laws. Yes, when I speak of the gender neutral laws, the first and foremost thing I speak is the POSH law. So POSH, it speaks about protection from the sexual harassment at workplace. So this enactment is very clear that the complainant has to be female. Okay, but what in case if a male undergoes a sexual harassment? That is not a uncommon thing, or that is not an abnormal thing that is going to happen, that a male is being sexually harassed. Yes, even the male can be sexually harassed. Now what he has to do? Over there, the law is very quiet about it. It is very silent. So it is at the discretion of the male. Either he can approach the HR. Over there, they have to check the HR policy if there is anything related to it. And if there is nothing related to it, even the HR will have a big question mark what to do next. Even if he goes to police station, even over there, he will not be finding adequate sections under IPC. Even there, he will be under trouble. And all this trauma, all these things, he will feel like, oh my God, I'm not going to file this at all. I am going to let it happen the way it has to. But it is not the approach and it is not the correct methodology. Now what happens is, like, because of this loophole in law, the many females, they take undue advantage of it. Okay, whatever I do, he has to bear it because he has no legal protection in it, wherein I have. Okay, there are many cases wherein the ladies, they themselves sexually harass their male colleague, and then they later knock the doors of ICC telling, yes, I am sexually harassed here. That poor fellow, because of this loophole in the law, is being stuck over there and is solutionless. Okay, so that has to be seen and that has to be addressed. Moving next, marital laws. Yes, this is one of the most burning and most happening topic, I should say. So I'll be speaking about marital rights. Yes, a male and female, they have right to choose their life partner, the right to lead their life, right to get all the benefits of the marriage. Now, the issue comes if something goes wrong, like divorce, maintenance, alimony, dowry laws. Okay, dowry, that's a very debatable topic. Now, when I speak about the divorce, what is this divorce? So, as all of us know, in the laws we have, like, the females has more grounds for divorce than that of the men. Okay, and I feel to an extent it is somewhere okay that they have additional rights over there, which benefit they can be availed. But I also feel that these rights can be shared with that of women, because the situation has changed. Today, the society is not as it was earlier. Okay, so there are many changes that's happening, and even the females are like going out, they're having good exposure. So I feel that the concept of the wife and husband in the marital laws has to be abolished, and instead of that they have to bring a single word, that is spouse. Next is maintenance or alimony. Now here in the maintenance or alimony, we have great precedents, which I'm going to discuss in the later stage at the fag end of the session, wherein we can see judgments wherein the husbands are told not to pay maintenance to their wives, and some cases the wives are asked to pay maintenance to their husband. Okay, so even we have such precedents. Now, why this law is being misused, or why the husbands are always made to pay more maintenance amount, is that ignorance. All of us know that ignorance of law is never an excuse, but people are ignorant about it. Okay, people are ignorant of the facts that something like this also can happen, and we have these laws, and the advocates will not be able to explore the law unless and until the client openly tells them about all the case facts. Okay, so the client will not be telling that yes, this has happened, that has happened. They try to hide the facts because uh, still we have a taboo that oh, she's a divorcee, he's a divorcee, or the divorce case is going on. So he's the advocate, and also the clients have trust issues that how can I tell my family secrets to him? He may tell it to somebody else. So all these things are there. So because of all these reasons, the advocates are not able to put their best. Okay, and I will not disagree on the fact if somebody says that yes, many advocates are also unaware of these facts. Yes, there are many advocates who are not knowing these precedents, and also who would not like to update themselves, with due respect to all of them. But yes, you cannot deny that there is nobody like that. It is not a false thing, or it is not a vague statement that I'm making. Now, with regards to this maintenance and alimony, as I said, we'll be discussing about many case laws which is in favor of the husband, and also the documentation over here. Also, it plays a major role. You have to have good documentation. You have to have all the records to make a point that yes, you are correct and the other party is wrong. Now, dowry laws. So, yeah, in addition to this maintenance and alimony, I would also like to add that now we have a judgment which states that the cooling period can be waived off in a mutual consent divorce. See, now, even if it is a mutual consent divorce, the husband and wife will have many issues. And even at that time, the husband will be harassed mentally, the husband will be harassed emotionally, husband will be harassed financially. So all the things would be going on. And even in the case of mutual divorce, the husband may be requiring the visitation rights to the child, the custody rights of the child, but he is denied that you will not meet the child till the case is over. And upon that, even in the mutual consent, you are giving 6 months of cooling period. So over there, we can file an application stating that this cooling period can be waived off based on that particular judgment, and tell that the marriage is irretrievably broken down, and there are no chances of parties coming up or the parties uh, joining each other, or the parties doing any kind of compromise. So over there, the advocate can present it in the court, and they can waive off the cooling period so that the mutual divorce can be done at the earliest. That 6 months period can be erased off so that the procedure is quicker. Okay, so we have all these provisions, but they are not invoked. They are not brought into action. Even today, I see there are many cases wherein the couple are staying apart for about 4 years, 5 years, and they do not have any issues between them. Even then, the advocates are not filing for the application for continuation of the cooling period. They'll be like, yeah, we have a cooling period, you please wait for 6 months. Okay, so what I feel that issue has to be seriously addressed, and these provisions of law which is enacted for the betterment of the society and to have a healthy relationship or to have a harmonious society has to be invoked. Next, we have dowry laws. So dowry is a thing wherein the gifts that is given during the wedding, and all of us know it is an undisputable topic that yes, men are harassed mentally, emotionally. Not only the men, even their parents, even the sister-in-laws, the fake cases. I would state that the amount of I think somebody is presenting. Can you please stop presenting? Whether my screen is visible now? Can somebody please confirm me if my screen is visible?
Your screen is not visible, ma'am.
Okay, yeah, okay, 1 minute. Okay, is my screen visible now?
Yes. Yes.
Yes, it is.
Thank you for confirmation. Okay, so if you see the statistics or if you see the figures, the cases which are fake are more than that of the original. Okay, and also engraved by all these things, we have many associations, we have many NGOs, we have many organizations who work for these kind of harassed husbands. They are titled as 428A Harassed Husbands Association. We have associations in that name also. See, that shows how deeply they are harassed. Now, again, why are they being harassed? What is making them from getting harassed from their respective spouses? Again, I would like to say that it is the myth that a man cannot escape from that of the clutches of a dowry case. Okay, so it is not that way. You have the right, you have all legal provisions in your favor wherein you can invoke them and you can come out of it. The example I would like to give you here is, so whenever a fake dowry case you feel that is filed against you or your client, then immediately try getting an anticipatory bail, quash the FIR. If any of the if any of the husband's sister, mother are made party of it, file a petition in the High Court, get their names quashed, get their names removed from that of the case, and also have all necessary documentation. Immediately file for restitution of conjugal rights and tell that you're wanting them back, or immediately file for the divorce, contested divorce, and also give a complaint against them, file an FIR against them telling that you are defaming me, you are defaming my family. So that way you can put pressure on them, that to make them feel that yes, even this person knows the law, and tomorrow if something is proved wrong, that I have fakely filed the dowry case, then I will be landing in the trouble. So once you ensure that, once you create that fear in their mind that it may bounce back to them, then they will be deterrent to do some act. Okay, then they would be coming to compromise with you, or they would take back their case and they would like, okay, fine boss, I'm sorry, okay, fine boss, let's settle it down, let's finish it. Okay, so this can happen. So you have to be very proactive, but you have to take actions on a very quick basis. Now, many of the time what happens is, like, when they file a dowry case, even though that person knows that it's a fake case, what they do is, like, they go to police station, they tell them file a B report or some report, and they do not do any other actions. They're like, oh, I don't want to file any other case, let me finish this dowry case, and after that I'll file a divorce case, let me do it at the later stage, let me take one things at once. Even many clients have this approach. In addition to this, many advocates also have this approach. But that is where the men are, that is where the other party is taking advantage of it, and they are like, okay, this person is quiet, this person is silent, this person is scared, so let me scare him more. Okay, so that thing happens. So over there, you should be having a proactive reaction or a quick reaction for whatever the other party is doing. Though for the fact that yes, it consumes a lot of your time, it consumes a lot of money too, but you have to protect yourself, you have to protect your dignity, and I think your mental peace is something more than that. Next, grounds to avoid maintenance or alimony. So how can you avoid maintenance or alimony? The first one is, if you are to the favor of the husband, or if you are on the husband's party, then I would always suggest pay maintenance amount. Do not pay alimony. Okay, now this depends on a case. If the wife, that is the ex-wife, if she is willing for remarriage or something like that, then you have to pay maintenance amount, because you can stop paying maintenance amount whenever the ex-wife gets remarried. So as soon as she gets remarried, or if you prove a point that she is having relationship with anybody or anything like that, then you need not pay the maintenance. Now, on the contrary, if you get to know that this your ex-wife, she is not having any plans of remarriage, or she's going to stay like this forever, and over there, on your side, if you're feeling that in the upcoming years you will grow financially very great, or your business will boom, or you will be making a lot of money, At that point of time, you pay alimony and you settle it. Because if your financial condition increases, then there are chances that the wife can ask you for increased maintenance amount. Okay, she can file for it and she can ask more money out of it. Okay, so that way she can do the thing. So now if you have to pay maintenance or you have to pay alimony, you have to decide it based on the facts of the case. So even there, you have to look into these parameters while deciding. Now, if you feel that paying alimony is better in this case because neither she's going to getting remarried nor you are going to earn money. So under those circumstances, you can choose for the appropriate method. Now, there are cases wherein, I don't know if I should be telling this on record or not, cases wherein the husband is a businessman. Okay, now his wife is asking for alimony. So now that husband is so adamant that he does not want to pay a penny to her. What will he do? Question mark. He will be suggested to show himself as bankrupt. That is, to show he is losing his money, to show he is not making good in his business, and also to not making not happening good things in and around. So that is why he is being declared bankrupt. So when he is declared bankrupt or insolvent, then he need not pay any money to her. Okay, so these are the modes wherein you can avoid paying maintenance or alimony. Now again, if she's earning more, yes, if the wife is earning more or if she is capable to bear her own expenditure, or if under those circumstances, then you can avoid paying maintenance or alimony. Now you have to prove it to the court. So how are you going to prove it to the court? You will be producing the documents, their degree certificate, you will be stating that she is working here because she was your wife. She might have shared your their ID cards or something like that. So you can have that point. And also it depends on the facts of the case. That is very much true. It differs from the one case to the another case. Over there, you have to analyze the facts and then you can do the plotting. Now, this heading is wrong. It is dowry. So grounds to avoid dowry case. Okay, let me correct it. So the first thing what you have to do is documentation. So when I say documentation, what documentation? So documentation in the sense you have to make note of all the gold that you have given to her, gold that you have received from their parents, and also the cash amount, the cash transactions, and also all the bills of the wedding, that preparation or wedding expenditure has to be preserved. Okay, so now these days we all have e-documentation wherein you can just scan a copy, you can put it in the Google Drive and you can keep it very safe. That has to be done. Now they will ask me, why do I have to have the bills of the wedding? That is because when the dowry case is done, now suppose you are the husband side and you have booked the chowdhury. Now tomorrow they will tell that we have booked the chowdhury. So what is the proof that you have that yes, you have booked the chowdhury? You don't have any proof. Over there, you can tell that chowdhury person, you have to contact him, you have to ask him which account did you get the money from, show me the bill copy that you have, if you have retained that. Now they may retain it or they may not retain it, or they may help you or they may not help you, nobody knows. Okay, so under those circumstances, have the documentation with you. Keep all the billings of the gold that is purchased, of all the bank transaction that is done, of all the things that has happened pre-wedding as well as the post-wedding. Next, affidavits that are received during wedding. Okay, so this affidavit will state that during the wedding you have received so much of gifts from the side of the girl, okay, from the side of the bride. And this is not given to you as a token of dowry, but this is given you as a token of love, as a gift. Okay, and this has nothing. This has been not demanded, nor this is not something that is expected. So you have to make an affidavit of that nature, and you have to have it signed in before the witnesses and get it notarized too. Now, what will this affidavit serve as? Now, if something goes wrong and if they file a dowry case against you, then already you have a document with you. See, yes, this is not a dowry. I have not demanded any dowry, but yes, they have given me these gifts worth these rupees as a token of love, as a token of gift during the wedding, but not as a dowry. This will be a great piece of evidence. And if you're not able to execute an affidavit, if you feel that, oh, this feels very bad, it's a new relationship, right? New family and other things, wherein you don't want to show your legal skills, or you don't want to show some negativity, because many people think that, oh, you are having a negative approach in your mind. Okay, so do not have that. Or even the girl child may feel that, okay, so he's preparing for all these things. Do you think that we are so crooked people? So all these words will come. So to avoid all those things, if you're not happy or if you're not approachable to do an affidavit, then you can have the video recordings, and also you can have the audio recordings wherein you are recording the calls, or else you are recording the videos and you are giving the statements wherein they are telling that, yes, this is, I have received it as gift. And do not make it an evident on the face that, yes, this is something which you are recording. Do it on a casual manner, so that tomorrow it should not be felt that, yes, they were forced or they are misrepresented to do that. Okay, so be careful, be cautious while recording the same. Next one is prenuptial agreement. Yes, prenuptial agreement is a piece of paper which says that if there is anything in the marriage, if anything goes wrong, if they are getting separated, then how are they going to separate? What is the maintenance amount that is going to be paid? What about the child custody? So all these things will be defined in this prenuptial agreement. Okay, so if you're not able to execute this prenuptial agreement, you can even go for a postnuptial agreement. Okay, so postnuptial agreement is the one which is signed, which is executed after the wedding is done. Prenuptial before wedding, postnuptial after the wedding. Okay, and now this prenuptial agreements again are not governed by any law in India. The only concern related to this is it should not be against Section 23 of Indian Contract Act. That is, it should not be going against the public policy. If your agreement lands up in court for its validity, the only factor that is going to be checked is it against Section 23 of Indian Contract Act. If it is not against Section 23, then these prenuptial agreements are valid. Now, again, the other factors, it depends on case to case. So what is your case? What is your case of facts? What are the circumstances that you are in? So based on that, further measures or further recourse can be taken. Now, false dowry case. So how to overcome a false dowry case? Now you have a false dowry case against you. What are you going to do? The first thing you are going to do is get an anticipatory bail. Yes, this is very, very, very important. You have to get an anticipatory bail. Next one is file for restitution of conjugal rights. Restitution of conjugal rights is filed when one of the spouse withdraws from the society of other without any valid reason or without any valid cause and does not want to come and stay back with him. At that point of time, we file this restitution of conjugal rights. So now if you want that spouse of yours, if you want your wife to come back to you, then you can file this case. Or else wherein you tell that, yes, I'm going to compromise with you, I'm asking you back, please come back to me, please give me another chance, we'll start, we'll have a fresh start. Okay, that is the purpose of this restitution of conjugal rights. Or else if you feel that, no, I'm not going to stay with her, I'm going to finally end up this marriage, then you can file for contested divorce. Next one is file an FIR for against opposite party for a false case. Yes, as I said, you can file a FIR against the opposite party for the false case. Then immediately file for defamation case. Defamation case is under Section 499 of Indian Penal Code, where you are stating that, yes, this person is trying to defame me, is trying to defame my family. is defaming my reputation, is causing damage to my society. So all these things you can file a defamation suit. Now, when you are doing all these things, what is the use of it? This will create a fear in the mind of the opposite party. Now, when you file a defamation suit, you will obviously ask for monetary settlement, compensation. Okay, so you will tell that you have damaged my reputation, pay me 6 lakh rupees. Now, if the dowry case is proved false and that person is, you are given a clean sheet by the court, then again that will help in the defamation case. Yes, see, you have filed a false case and because of that you have to give the money. So go for the FIR, do not have a step back and tell that, okay, fine, this is going on, let it finish, then let me take it. No, do not do it. And if you are not able to file the defamation case on this particular fact itself, dowry itself, you can file defamation case in other manner. Like she's going to near in and around and she's telling to the relatives that I have asked dowry, she's telling that I'm having relationship with somebody, she's harassing me, she's telling my kid not to speak to me, she's coming to my workplace and she's doing that, she's doing this. Obviously you will have few other more grounds and over there you can attract the defamation suit or you can attract the complaint against them. Now next, other issues or other recourses are depending on the facts of the case. So these are the few recourses available on a general basis. Now again, this recourse can be made better use of and additional recourses also can be added depending on what is the nature of your case, how old is your case, how adamant is your case. Okay, so all based on all these factors, understanding them, then we can avail for the recourses. Now next, fatherhood. All of us, we speak of motherhood, we speak about motherly love, we speak about the child's affection towards mother and mother's affection towards a child. But the most underrated topic is fatherhood. Nobody understands the emotion of a father, nor they understand the emotion of a kid towards the father. Now, yes, because the men are not vocal about their fatherly love for kids, that doesn't mean that they do not have that fatherly feeling in them. So now we are going to cover a few of the fatherhood laws, that is child custody, adoption right, as well as the visitation rights, and also the grounds under which they can visit the child. Now, so how can you become a father? To become a father, you have two modes. The first one is biological father or legal father. Now, again, in the biological father, you have two modes. That is natural or biological mode. Second one is artificial mode or surrogacy mode. Whereas in the legal father, you have another two modes, that is adoptive father or stepfather. Now, biological mode, as that is a natural mode, all of us know. So, by biological, by the reason of the birth, you become the father of the child. And second one is artificial mode, that is by surrogacy, you can be the father of the child. Now, we all of us know Cristiano Ronaldo, I think he has 3 or 4 children out of the surrogacy mode, wherein the name of the mothers are kept secret. Only the name of the father is brought into limelight. Only the name of the father is disclosed. So he is also the biological father of those 3 children. Nobody can deny or nobody can dispute that he is not the father because he has not disclosed the name of the mother. According to the surrogate agreement, whatever he has entered with them, those surrogates' mother are not permitted to disclose their identity in the public. Okay, that does not mean that Cristiano Ronaldo is not a biological father of the child. Cristiano Ronaldo is the biological father of the child, and that is undisputed. Now, legal father. Legal father is the one who has achieved this or who has attained this fatherhood title of father by the legal mode. That is by adopting somebody or by being the stepfather. So what do you mean by stepfather? The stepfather is the one who has married your biological mother. Okay. So now by marrying your biological mother, they become stepfather. And how do you change the documents? Just by their marriage, he does not become your stepfather. To be your stepfather, he has to undergo an adoption procedure. So to adopt you and to be titled as your father, he has to file an application with Kara, and they will scrutinize the application. And once the application is scrutinized, then both the biological mother as well as the biological father will give a NOC that I have no objection for him to be the stepfather. So once this NOC is received, and also they'll see that there is no petitions pending in the court regarding the child custody, and the child custody is all sorted. So once these two NOCs or these two clearances are done, then they will be titling him as the stepfather. Okay, so if the child custody is in dispute, just by marrying your biological mother, that person will not become your stepfather, nor he'll attain the status of the stepfather. He will be just your mother's husband and not your stepfather legally. Okay, again I quote here, legally. Emotionally he can be, but not legally. To do the legal thing, he has to follow up with these compliances. Adoptive father, all of us know, by mode of adoption, an orphan or any distant relatives or whatever it is, by whatever mode they adopt you, and then they become the adoptive father. Next, guidelines for adoption. So how is the adoption is done? So for a male to adopt a child, he has to be physically, mentally, financially, and emotionally stable person, and he can adopt only son. And non-residents and non-citizens are also eligible to adopt in India. And the age criteria: he should be less than 45-year-old for adopting a child less than 4-year-old, and should be less than 50 years for adopting between 4 to 8 years, and should be less than 55 for adopting between 8 to 18. So once you attain 55 years, you will not be able to adopt a child. The reason for this is the biological expectation of a human lifespan is 60 years. Now, at this span of time, you are 59 or you are 60, and you adopt an 8-year-old child, and something happens to you tomorrow. Then who's going to take care of the child? Okay, so to evade all these things, to evade all these possibilities, the lawmakers, they have brought this age cap. Though this has been questioned that we don't want this age cap, or we do not want this to be believed, there is no age for adoption, there is no age for fatherhood, but yes, there is age for your body, there is age for your death. Okay, so after your death, the child should not be suffering. So that is the reason why we have this age criteria for the adoption. And the age gap between that of the child and that of the father shall not be less than 25 years. That is, you can adopt only after you attain 25 years. This is because now if there were many cases wherein the children were adopted, and then later on they were exploited sexually, and also they were adopted just to take care of the home course. So all these things were happening on a larger scale. So considering all these things, they have brought this 25-year age gap. But yes, this is not applicable if you are a stepfather, a step adoption, or this is in-house relative adoption. Okay, so under those circumstances, this is not applicable. Next, grounds for custody of the father. Yes, this is very disputed thing, that what is the ground for custody of the father. So usually the courts, they tell that yes, the mother is a custodian. Even the law says that yes, the child at his childhood needs mother more than that of the father. Yes, the child needs mother more than that of the father, but the child even needs the father. Okay, so it does not mean that the child does not emotionally need father at all. Especially we daughters, we are more dependent on our father than that of the mother. Though for our biological changes, for our physical changes, to explain those factors, we are more comfortable with our mothers. But on the other hand, for all other matters, we are more comfortable with our fathers. Okay, so yeah, that is always there. So that has to be balanced, and I'll be discussing about few case laws the judgment which is passed recently by Karnataka High Court, wherein it spoke about the shared parenting, co-parenting. So before we go for that, let us understand the grounds wherein the father can ask for the custody. The first one is, if the mother is willing to give up the custody of the child. So if the mother says that no, I don't want the child custody, the father can take it. Then under those circumstances, the father can have the custody of the child. And if the mother is insane, that is the mother is not able to take care of the child, she is going through some mental disorders, or she is having some physical impairments, then at those circumstances, the father can take care of the child. And if the child is of 13 years and expresses his or her wish to stay with the father, that is, if the child desires that, yes, I am going to stay with my father, then the court can grant the custody of the child to the father. And if the mother is of immoral character, so now if the mother is not having good ethics, or if she is of an immoral character, then the father can prove it beyond reasonable doubt in the court and can get the child custody. Next, the financial incapacity of the mother. So now in case of financial incapacity, many a times the court will tell that, yes, the father has to support the child, financial matters, and the father has to give the maintenance to the child. But even at that point of time, the father can make a point that if the mother is uneducated, or if she is staying in a very remote village, or where there is no basic amenities, or she is less responsible or not at all responsible, or she is having no family support in that matter, or she's working like 24/7 and she's having no time for the kid, or as the child is being emotionally disturbed. So you can invoke all these grounds, whichever is suitable in your case, and then you can ask the court to give the custody of the child to the father. And next one is, the background of the mother has been in dark. That means that she is uneducated, or she is illiterate, or she is not concerned about the education of the child. She is giving him all the freedom, or she is spoiling him, and also if the child is being continuously instigated against the father, or she is trying to do that, or she's trying to use the child against him to harass him. So under those circumstances, the father can gain the custody of the child. Now, if the mother is a convict herself, that is, if the mother is being convicted in any of the case, like not only in this case or any matrimonial case, but also if she is convicted in any cheat case, or any fraud case, or any other case for that matter, or she is being imprisoned, or a trial is going against her and she may be jailed, or she may be imprisoned, so then under those circumstances, the father can get the custody of the child. Not only these circumstances, but also there are other circumstances wherein the father can ask for the custody of the child. Again, it will depend on the particular case. Now, if the father makes a point to prove that, yes, he will provide more education or more facilities to that of the child than that of his mother, or he is more emotionally attached, even the child and the father are each other, or the child needs his father more than his mother. So under those circumstances, the father can get the custody of the child, or they can even go for the shared parenting. Now, next one is visitation rights. So what do you mean by visitation rights? Visitation rights is wherein the father is allowed to visit the child. It is a part of the custody. Like you can visit the child once in 3 days, or you can visit the child once in a month, twice in a month, once in fortnight. So depending on the location, geographical location, or the emotional need, the child's age, and all these things, it will be decided. Now, if the child is about 1 year or 2 years, then the child's memory is like, it will only recognize the people whom it sees on a regular basis. Now, at those times, the father can tell that the child is very small, I have to meet the child once in 2 days or once in 3 days, so that the child remembers me, the child gets attached to me. If you visit a 1-year-old child once in a month, or twice in a month, then the child's chances of recognizing you is very scarce. It will not be recognizing you. So you have to visit the child more frequently. So you can ask the visitation rights based on the age of the child. And yes, because he is the father, he has the right to visit the child. And where they are going to visit, how they are going to visit, all the things will be decided in the divorce decree. Okay. And also they are whether any activities are allowed, like whether any they can go on a trip or they can go on a outing, or how are they going to control the rights that control during the visitation, that is, are they allowed to take him for a drive, or is he allowed to meet the child only in the closed premises, or that is only in the home, or he should be accompanied by the mother wherever he takes the child. So what are the things? And also, is he allowed to take the child out of the state or out of the country? So what are the things, and how is he going to take care? Who is going to pay the expenditure? So all the things will be decided in that of the divorce decree. Okay, so I hope this visitation rights is clear. Now, next topic, how to escape from the marital, that is legal harassment. The first one is pre-nuptial agreements. Yes, pre-nuptial agreements, as I said, they do not have any specific legislation in a country like India. So here what we have to do is we have to analyze, and we have to frame law such a way that it is not contrary to Article 23 of the Indian Contract Act. That is, it should not be going against the public policy. That is, you cannot tell that you cannot curtail their grounds for divorce. Okay, now the husband cannot make a clause in the contract stating that if I get an extramarital relationship, that is not a ground for divorce. Okay, and also he cannot make all those statements, and they cannot make a statement that you should not be accessing my mobile and I will not be accessing your mobile. No, all these things should not be there. It should have the clear-cut statements, and also it should not be having the statements that if there is a boy girl, I am going to if there is a boy baby, I am going to take care of it. I am getting the custody right. If it's a girl baby, you are going to get the custody of it. No clauses like that. The clauses should be in consonance with that of the public policy. That is, it should state that in the case of divorce, on any grounds that are mentioned by the law in force, I'm going to pay you this much of amount. And whatever the gold that is received during the wedding shall be distributed so and so. Whatever the expenditure of wedding shall be claimed by so and so. So that way it has to be drafted, so that it is not against any of the policy. Now, by drafting these kind of agreements, that is prenuptial agreements, the parties will be on the safer hand, and if anything goes wrong, there will not be any kind of harassment. All they have to do is that they just have to go do the divorce proceedings and come back, finish. Okay, so that will help them from the legal harassment. Now, affidavit of all gifts received during wedding. This is most important to protect yourself from that of the dowry cases. Next one is documentation. As I explained, from the receipts that you have paid for the wedding hall, booking, flowers, all the receipts you have to keep. Okay, and in addition to that, you have to keep all the other documentation. Either it may be your wedding card, the expenditure for the wedding card, and also if possible, have it in a mail communication that all these things were done, so that you can have a record of all of it. And avail the first approach benefit. Yes, this is very, very important. Now, if you feel that you will be framed in a false case of 498A, or you will be framed a false case of harassment or something like that, then you be the first person to approach the court. Okay, so this first approacher, usually the mentality or the human psychology is that, oh, he has come first. That means he has not done anything wrong. If he was wrong, he would not have come. So this is a common psychology. So we always take that psychology and apply that and get the benefit out of it. Okay, and next one is based on the case facts. Yeah, so whatever your cases are there, whatever the facts are there, so you will be able to decide it in a better manner once you go through the facts. Okay, now here the only thing as an advocate or as an victim or something like that is to look into the case facts and find the loopholes and turn the table so that it benefits you to the maximum extent. Okay, at the end of the day, whatever it is, however it is, not however, whatever it is, you are supposed to get justice to your client. You should not be letting an ignorant person or an innocent person from being framed under a false case. Next, we will be looking up a few judgments. The first case is Jyotsabhen Ratilal versus Praveen Chandra Tulsidas. So in this case, what happened is this Praveen Chandra Tulsidas, he got married to his wife, and once he got married, he got to know that his wife is important. So what this fellow did was he waited for a longer period of time, and also he was getting constant medical treatment for his wife's medical thing for his wife's treatment, and he did all the things that are possible. So after 6 years of married life, he did not find any solution for the impotency of his wife. So now what he did was he filed a petition for annulment of the wedding. Okay, so the ground for the annulment of wedding or ground to file it was the wife's impotency. Now the wife made a statement that 6 years of married life we had together, and now the limitation period is barred. She said, you have been here with me for 6 years and now you are filing for the important. So what were you doing for all these years? So now the court, it passed a judgment in favor of the husband. It said that, yes, the husband has waited for 6 long years for the medical treatment of his wife and some miracle to happen so that the medical science could find some cure. But nothing did not happen in that span of period. That means that this delay which was held is not unnecessary or not improper. So the court upheld the delay of 6 years, and also it condoned the delay of 6 years, and it annulled the marriage on the ground of impotency. So now here you can see that, yes, though there are laws which are in the favor of female, in this case, the husband won the case. Next case that we are going to study is related to the maintenance. That is, what is capable of earning and what is actual earning. Now, this is a very debatable topic because we have judgments which state that even if the wife is capable of earning, she can be denied of maintenance. But whereas we have few judgments which states that even if the wife is capable of earning, they should consider her actual earning. Okay, here the second point is calculated because the wife would have taken a gap in her professional life to provide justice to her, complete devotion to her matrimonial life, or to provide extra time, all her time for the child. So all these things are there. That is why the court has said that you have to look into capable of earning and actual earning. So now again, it depends from one case to the another. Now we'll start with a case that is Shailaja and others versus Kombanna. So in this case, the Supreme Court of India differentiated capable of earning and actual earning. So it said that just because a wife is capable of earning, it does not mean that she is actually earning. She may be have taken gap in her career. She may be having career gaps, or she may be having a small kid to take care of it. So that is why here the court said that just because she's capable of earning, just because she had the degrees with her, that does not mean that she should be given the she should be deprived of the maintenance. Even then she can seek the maintenance. Now here in other case, that is Rupali Gupta versus Rajat Gupta, in this case, what happened is the wife is a chartered accountant and she was in profession for so many years. Now, here the court said that though she is a chartered accountant and she is earning very well, that means that she is not capable of, or she is not entitled to claim maintenance. Okay, so she said that the court stressed upon the fact that wife is a well qualified and capable of earning, but chose to remain idle. That is, though she was having CA degree, she did not want to work. She wanted to stay back at home. Okay, so in that cases, the court did not award any interim maintenance to her. So now here you can see that the judgments are contrary to each other. In Shailaja and others versus Kombanna, the court said that you are supposed to give the maintenance to her even though she is having degree. Now here in Rupali Gupta versus Rajat Gupta, it said that she has a CA degree and if she chose to remain idle, then she is not going to get the maintenance. Now you are in confusion like me. So the answer for that is it will depend on the case facts as well as on the mode, how are you presenting the case. So it will basically show or it will be basically depicted by the mode of the presentation. So how are you going to present? And what are the documents that are you going to produce in supporting your claim? Okay, so all these things has to be in consonance to the statements that you are making so that you are on a better side and you are on a safer side in this matter. And also here the maintenance law are not totally that it is towards the females only or it is something like that. So here this second case law, Rupali Gupta versus Rajat Gupta, is a fair example that yes, the females can be denied of the maintenance. So I hope this concept is clear for you. So it will depend on the picturization of the entire case and your presentation. Next, Rani Sethi versus Sunil Sethi, which is this judgment is passed by Delhi High Court. So in this case, the wife was directed to pay maintenance to her husband, that is rupees 20,000 per month and 10,000 as litigation expenditure and also a Zen car for the use of the husband. Now you are shocked. Okay, so how is this even possible? Yes, this is possible. So it said that it referred to the section 24 of the Hindu Marriage Act. And in this, the brief case facts is this Rani Sethi and Sunil Sethi, what happened is like they both started a business together. And this business was basically invested by Mr. Sunil Sethi by selling all his ancestral property and some of his self-acquired property. He had invested in the particular business. So now what happened when this divorce case came up, when the things happened, this Rani Sethi, she was having the major stakes of the business and she took all her stakes and she kept it for herself and Mr. Sunil was left with nothing. So now he approached the court telling that, yes, we started a business, we were doing it great. Now all of a sudden she has put me out and I am with nothing. Then the court said, yes, this lady is earning good. She is making good business out of it. That is why she should be paying 20,000 per month plus 10,000 as litigation expenditure and also a Zen car for the use of the respondent husband. So now this is an answer to this case law. This judgment is an answer to all of those people who tell that the husbands cannot get maintenance amount from the court. No. The husbands can get maintenance from their spouse, from their wives, based on the judgments that are provided in the past in the courts. Now, all it depends on your case facts. How do you picturize it? How do you present it? And how strong your documentation skills are. Okay, as seen in the movie, it is not those advocates who run behind the people, who collect evidences and who present it to the court. No, it is you who is going to record the statements, record the evidences for a longer period of time and submit it before the court. So this is a landmark judgment, that is Rani Sethi versus Sunil Sethi, passed by the Honorable High Court of Delhi, which provided maintenance of 20,000 per month to the respondent husband and 10,000 as litigation expenditure in addition to that of the Z car. Now, next one more example is this K. Vinaya versus B. Srinivasa. So this is a very landmark judgment which was passed in the year 2013. Okay, so this brought the concept of shared custody. Okay, and also it considered the well-being of the child and also the sustainable growth. Now, in this case, what happened is both the father and the mother, they wanted the custody of the child. Okay, so they were fighting with each other. So what did the court do? The court said that, yes, the first 6 months of the year, the child is going to live with the father. The next 6 months, the mother is going to take care of the child. Okay, so in a year, out of 12 months, 6 months, the child is with father, 6 months, the child is with mother. And all the expenditure of the child will be split equally between that of the father and the mother. So here, the concept of equal and shared parental responsibility was brought into force. So after this judgment was passed by the Honorable High Court of Karnataka, many judgments were passed on this basis of the shared custody and sustainable growth, and also on the basis of this shared parental responsibility. So this is a very landmark judgment, and on which even the fathers can get the custody of the child equally as that of the mother. Next, we have Mrs. B.S. Deepa versus Regional Passport Officer. So this is a case which I'm here specifically mentioning to speak about the fatherhood. Okay, so what happened in this case was the biological parents, they got divorced to each other, and the biological father of this petitioner, he was not in touch, he was not at all in connection. The mother raised the child independently, and in due course of time, the petitioner, the petitioner's biological mother got married to her husband, and then via adoption deed, this girl was adopted, and that is how he became the stepfather. Now what happened is, she applied for the passport. So in the passport, the name of the biological father was reflected instead of the stepfather. Now they filed a writ of mandamus. So writ of mandamus is a writ which is filed seeking an order to do or not to do for an government office. Okay, so now she filed a writ of mandamus to the Supreme Court stating that the respondents, that is the petitioner, shall replace her biological father's name with that of the stepfather. Now the court, by hearing all these factors, it made a note that yes, the biological father was there, but he was never emotionally connected, nor he was emotionally available to the child. So this stepfather was always there for her, was emotionally available, and he is the current father. And the fatherhood of the stepfather was recognized, and an order was issued to the regional passport officer stating that within 4 weeks of time, the name of the stepfather should be reflected in that girl's passport. Okay, so that is how the fatherhood of a stepfather is being recognized in our honorable court. That is apart from that of the birth certificate. You cannot amend the birth certificate, okay? Because it is believed that every person has a right to know who is his biological parents. That is why you cannot amend a birth certificate. Apart from that, you can amend any other documents. You can amend your parents' name in your passport, in your Aadhaar card, in your PAN card, any document for that matter, but not in birth certificate. So the fatherhood was recognized here, and this writ of mandamus was allowed. Next, we have Chandramohan Jain versus NK Bagorida Public School. Again, this is a writ petition. So now in this case, what happened was Chandra Mohan Jain, he is a private school teacher who availed this paternity leave. Okay, and his salary got deducted by the public school. Now he filed a petition in High Court of Delhi telling that he had taken this paternity leave for the taking care of his wife and also his newborn child. And the High Court said that though there is no legislations, the concept of paternity right was upheld. It said that yes, there is no legislation, the HR policy of the school does not say anything, nor there is the school is aided from the government. It is totally a public school, that is, it is totally a private ownership. In spite of all these factors, his paternity leave was upheld. And the court then directed the school to refund the deducted amount, that is the deducted salary amount, to Chandan Mohan Jain. Therefore, it provided relief to the private sector teachers. Though we have this precedent, like in the year 2019, it's more than a decade, not, I think 12 years, yeah, 12 years. Even in spite of that, many of these organizations, they have not introduced this paternity concept, paternity leave concept. Apart from that of the few MNCs, we do not find this concept anywhere. And we have this judgment by the Honorable High Court of Delhi, which can be availed to take the paternity leave along with the salary. So this is also one of the very great landmark judgments that we have received way back in the year 2009. Next, this we discussed, Deepa we discussed, I'm sorry, the slide is repeated. Yeah, next we have Shefali Chawla versus Union of India. Again, this is related to the passport, wherein the name of the stepfather was in the birth certificate. Okay, so she asked for the same thing. And again, in this case also, the petition was allowed, and the court ordered the passport officers to fill her stepfather's name in the place of her biological father's name. So wherever her father's name is, biological father's father name is to be written, therein she can write the stepfather's name. Okay. Yeah. Next, yeah, birth certificate is not amendable, as I said. Next, we have few cases. Now, the first one is Kalpana versus Surendra. So, in this case, what happened is like this lady, she filed a false dowry case against him. Okay. Now, what happened is like they lived for 1.5 months with each other. And she humiliated the respondent. That is, she humiliated Mr. Surendranath, her husband, by not giving him tea and something else. And this lady, she went to the college and she never came back. And after that, she filed a dowry case against him. And also, the court said that the court accepted Mr. Surendranath's version. It said that yes, she is doing cruelty to them. And that is why, to cover herself, to bring herself in the good books, she had filed a fake dowry case or a false dowry case against him. And also, the refusal of contribution in the household work amount to cruelty. That is, now if I ask somebody to give me 1 cup of water, and if they refuse to give me, yes, that amounts to cruelty. So even in the case, in this case, the same thing happened, wherein Surendranath, he asked her for her to give the coffee, and give the tea, she refused. And constant act, and also she further humiliated him. So all these things amount to the cruelty. Now this cruelty is a wider concept. Now when I am eating food, if somebody says me in my household that, oh, how much food you are eating? Oh my God, you're eating 3 parathas, you're eating 4 parathas. My God, my goodness, how big your stomach is. Even though they mock at me in that manner, even that amounts to cruelty. Even that things I can frame it under the cruelty concept. Next one is Satya versus Shriva. So in this case, what happened is like the wife, she terminated her pregnancy without informing her husband. Okay, so now the court said that if the wife, he filed a divorce for the ground of cruelty, that she is doing cruelty towards me and she has terminated her pregnancy twice without my consent or without even informing me. Even I was not aware of it. So now the court said that yes, she is she's depriving of his right. She's not even informing him that she is being pregnant and she is being terminating the pregnancy, and all these things, it amount to cruelty. Okay, though it is her right, it's her body to give the birth to the child, even then it amounted to cruelty because that person is the father of the child. So that is the place where the fatherhood of the child is upheld. Next, we have Anil Bharadwaj versus Nirmalesh Bharadwaj. Okay, so now here in this case, what happened was like they were married on 31st 1, 1979. And after the marriage, she was not used to do any household chores. Okay, so when she was asked, she said that no, I'm not used to do it, so I'm not doing it. But then the husband also did not bother it. Okay, and when their husband went to his in-laws house, they recommended him to stay separately with his wife from his family. Okay, so they said that you should not be staying with your parents, you should be making a separate home, etc., etc. And also they did not this fellow Anil Bharadwaj, he refused to do that. He said, no, I want to stay with my parents. So what did they do was they did not allow him to do indulgent sexual activities with her. Okay, and whenever there was some intimate moments, she used to get furious and she used to tell the same thing, that you are not leaving your parents and you are not coming to me. That is why I'm not allowing you. So let us have a separate house and let us lead our life separately. And then I'll permit you. Then I'll let you do the things. So this engraved him, and he filed a petition for divorce. And then he said that. The court said that yes, this is a ground for cruelty. Now the first thing is you cannot tell that you have to leave your parents and you have to come with me and all other things. And second reason, you cannot blackmail him or you cannot threaten him that no, I will be allowing you to do sexual intercourse with me only when you leave your parents and come with me. But now today, this is a very debatable topic as a marital rape, and it is a very sensational topic which I don't want to invoke or I don't want to bring into action in this particular session, because I want our honorable courts to decide whether marital rape exists or not. And once the honorable court decides, and then I think we can have a talk on this. Next one is Prem Chandra Pandey versus Savitri Pandey. So in this case, what happened is like this was a dowry case. Okay, so she had filed a case against the husband and family that they demanded dowry from her before the marriage as well as after the marriage. And she stated that he tortured with them and all he was having extramarital affairs and so many things she had put, and she was not able to prove it to the point that yes, this is a true fact. Therefore, this case was withdrawn, and a false case like this is a ground for divorce. So based on that, she can have the ground, she can invoke the grounds of, the husband can invoke the grounds of cruelty for the divorce. Okay, the fake allegations of the adultery also amounts to cruelty. That is doubting him and or also telling him that yes, you are having an extramarital relationship or you are in affair with somebody. So even that is a ground for the divorce. Okay, even that amounts to the cruelty. So now, while looking into all these cases, we felt that yes, now at the general concept, if I had told you only the facts but not the judgment, then you might have felt that okay, the husband might lose the case here. But the tables turned. Over here, the wives have won the case, they have achieved it, and they have done a good thing. Okay, that is where it all stands, and that is all what it matters, like how you are presenting the case, how good you are at researching, how well versed you are with law, and also stay positive that yes, you are going to get justice for your client and you are going to win this case. Next, yes, when I was researching for this men's rights thing, all I could get was we don't have a special ministry for men, wherein we have a ministry for wild animals, we have ministry for water, we have ministry for air, we have ministry for everything. But why don't we have a ministry for men? Well, that's a hot topic, and yes, uh, doing it a ministry for men is a question that's an open-end question. And more than that, what I feel that we have, I think that's my personal opinion, we have human rights. I think we have to march towards being humans more than being male and female, or being more than men and women. At the end of the day, we are all human beings. We are all made of blood and skull and flesh. That we have to remember, and we have to march towards it, instead of looking into the ministry for men, especially for women, especially. So I think we should be going towards for ministry for human rights, which we have. And yes, before winding up, I would like to state that precaution is always better than cure. Yes, it may feel strange, it may feel absurd that yes, how do I do it? Should I be doing it or not? Or what it is, how it is, etc., etc. But I feel yes, precaution you have to take. Either you are a male or you are a female, or you're going to play the role of husband or wife, whatever it is. Either you are an in-law, irrespective of the factor, you have to take all precautions. You have to keep all the documentations. Place all your emotions, all your love on the left side of the brain or the right side of the brain, and the other part you fill it with the legal concepts. You learn from seeing other people, you learn from reading the newspaper, you learn from your experience, you learn from others' experience. So learn from all these concepts and keep that in your mind, so that we can have a better future and a better life. Because anything can happen. Nothing is permanent in this temporary world. Okay, so what about emotions and other things? It may change, and also the money, it has its own value. Whatever we state, whatever we tell, we value emotions, etc., etc. At the end of the day, money is something which is going to fill our stomach, right? More than our heart, we need to fill our stomach. And yes, though it is a kind of bitter truth that we have to accept. More than truth, I would like to state that it is a fact that we have to accept, and we have to move on with it. Okay, yes, next, yeah, any questions? I'll go through the chat box. 1 second, let me stop sharing. Okay. So I'll be going through the chat box. So if you have any queries, please do drop in the chat box, or else you can even unmute yourself and you can ask me the questions. Yeah, let me go here. If you want me to repeat any of the things, or if you want to repeat any of the concepts, or if you want to discuss any case studies, do not reveal the identity or the case name or the case number or something like that. But instead of that, you can give a imaginary name, something like that. Yes, okay, so good evening, everybody. Yeah, thank you. Pavan Rajguru, please clear the second point. Please let me know which second point it was. Now I have one more question from Pavan. Caste certificate. Yeah, caste certificate, the names of the caste certificate, right? Like the father's name, if I'm not wrong. Yes, you can change all the names, all the fathers and mother's name. If you are adopted by your adoptive fathers, adoptive parents, then you can change their names in a caste certificate. Only you cannot, only the birth certificate cannot be amended. Apart from the birth certificate, all other documents can be amended. Yeah, can we get the PDF of the presentation? Can we get this PPT? Yeah, we are sharing this PPT with the persons who have opted for the e-certificates. However, the recorded sessions will be shared with all, wherein the PPT, the study materials, will be shared with that ones who are opted for the e-certificates. Yeah, so any questions? I had, while organizing this, we had kept half an hour for discussion because we knew many questions would be popping up. Yeah, Shan.
Madam, PPT 12, Article 53, you said something that pre-nuptial agreement, ma'am.
Yes.
And same as the Article 53 of what, ma'am?
Section 23 of Indian Contract Act.
That, yeah, but same thing on PPT 23, you said some articles of number. What was that?
No, there is no article, I guess. Pre-nuptial agreements, wait, let me go back to the...
That first approach, some benefit, at that time you said some article.
Let me share. 1 second.
12, PPT 12.
Yeah, so there are no articles here.
But you said, okay.
It
Then
is
it's
section 23. Yeah, if I'm...
yeah, that is the Indian Contract Act. The section 23 of Indian Contract Act.
Yeah, section 23 of Indian Contract Act. It should not be violative of section 23 of Indian Contract Act.
Okay. Okay.
Ma'am, is there any judgments regarding male sexual harassment? Male sexual harassment, males do not come and lodge complaint of sexual harassments. I looked for a case wherein I could find sexual harassment wherein male had undergone, but I couldn't find anything great. If you start researching about male sexual harassment, all you will be bombarded with the thing is like that movie of Akshay Kumar and Kareena Kapoor. What is it? Aetras. Yeah. So you will get all the reviews of it in the Google. Even in the Google Scholar, I couldn't find anything related to the cases like landmark judgments related to male sexual harassment, because it is very rare factor that male come up and they'll be sharing these things. Yeah, when we'll be getting the e-certificates and materials? By tomorrow mid of the day. By tomorrow afternoon, you will be receiving it. The recording, I'll try my best to upload it today. If it is not done by tomorrow afternoon, for sure. Yeah, well, we had more than 200 registrations and I'm finding only 19 people here. Yeah. Yeah, the ones who have opted for the e-certificate, I have downloaded the attendance also here. Please do share the screenshot along with your full name as you want it in the e-certificate, so that it will be easy for us to generate the e-certificate. Yeah, we take attendance in that manner, because if we download it and if we do it in our view, people will be like, oh, I had attended when you downloaded, I wasn't there, etc., etc. So we ask people to give their attendance in the way of screenshot. Yeah, Rachel, so you have any questions?
Hi, I wanted to appreciate your the whole explanation part. I am very new and I really liked it. I was like 5 or 7 minutes late, but and I'm a non law student and I studied commerce, so I had law for like 1 or 2 of my semesters, but I understood in depth every single word that you said.
Thank
I
you.
wanted to. I don't have any question except for the certificate part,
Yeah,
but yeah, I just wanted to appreciate the fact that you
thank
explained it
you.
really well.
Thank you. Thank you so much. See, it is the objective, right? It is the end of the day. As a speaker, I would, when I have a mixed audience, I would try to my best to get ensured that everybody has understood the concept. I'm really happy. Thank you so much.
Right, and I think the last point, we should have a special ministry. I really agree on that because since I had my black book, like that was my final year project made
Okay.
on children's rights. That was on POSCO, and throughout my studying years, I was literally up to women's rights. So I never really took a depth and studied about men's rights, and this really gave me a new perspective. So I'm really glad about it.
Thank you. Thank you. So, what do you feel? Do we want to have a ministry for men, or human rights is sufficient?
I think we should have a ministry for men because my brother, he always says that the men are wrong and he's only 12. I mean,
Okay.
he sees so many things. I mean, the children nowadays are really digitally sound, so he sees a lot of things. He's even reads, and he's like, if this happened and a woman has a special law, why doesn't a man have something that supports him or pushes him? So I saw it in that, and I'm telling you, it's very clear. I think we should have one
Yeah.
for men.
See, the women's are propagating that yes, men should have some men's ministry more than men.
Yeah,
I think it's a point that men should be very glad of and proud of us.
correct. And I completely agree because even today in this, I mean, I'll just speak something about my college. That see, if a guy wants to approach a girl, he has to think twice. And we've all started from co-ed because she might take the wrong impression of him coming towards her and even talking about some things. Whereas if a girl wants to approach any guy, she's very free to do so because she was just taking help. So that doesn't count as a wrong thing, and I don't think this equality at all. Or I really think that this is wrong, and this helps out a lot. And even in my college, we have a women development cell, but there's nothing that supports men at all. So I
Yeah.
think this is really great. Now, I also wanted to ask about the certificate thing.
Mhm.
Like I enrolled last minute today. I mean,
Mhm.
I was logged in through LinkedIn and it gave me a pop up, but I contacted someone on WhatsApp and they gave me the link. That's
Okay.
how this happened. So I have filled out the form. Now, how do I get the certificate for
Yeah,
this?
I'll be WhatsApping you regarding this. I'll be
Okay.
WhatsApping
Okay.
you on the details of the process of
Okay.
certification.
Okay. All right. Thank you.
Yeah. So, yeah, any more queries or any
Ma'am,
feedback? Yeah, Shanmugam.
I want to thank you first of all. This is the first lecture about men's. I think what you have done is there are no words to express because I have undergone this matrimonial dispute for my son for the
Mm.
past 6 years. It was hell. Even if God puts me in hell, it will be like a heaven only because all these things I have faced here. I want to add only one thing:
Yes, sir.
boy or girl,
Mm.
both of them there should be equal rights. It is all in the thing or constitution and whatever it is, the law enforcement thing. But the only thing is law enforcement people, they do not take the grievance
Mm.
against men. If they complain, they will ask you to keep quiet. You adjust with your girl. That is
Mm.
what they say. The what you said, the what is the defamation suit, FAR, it's a very laborious job in court.
Mm.
Getting numbered, it's a big problem. By that time, compromise will be there. So
Mm.
whenever we approach here and there, the
Mm.
compromise will come. But human rights, no, those
Mm.
people without any that what to say, any monetary benefit are there. They work. They,
Mm.
I had to write a ministry, law ministry, president. I contacted all person because I had a harassment by the law enforcement people.
Okay.
So when I contacted them, then the national human rights and state human rights, they came to help me. At that
Mm.
time only we got that thing and the compromise was there. We get rid of thing. Now I had a second marriage for my son and a granddaughter is 7, 8 months old.
Okay.
So today is her that is 8 month old birthday. What
Mm.
really, it's a wonderful thing. Your session was really beautiful. I thank you and thank you. Your II and that what
I agree.
oh, IIPS India. So
Yeah.
this is the second program I am attending. So
Okay.
very
Okay.
beautiful, ma'am. Thank you, thank you, thank you.
Thank you. Thank you so much for the feedback, sir. Thank you so much. See, it is like at the end of the dusk, there is something wonderful waiting for you. I am so glad that you are having a happy family again, in spite of whatever you have gone through.
Thank you, ma'am. Thank you.
Yeah. Yeah. Any queries? Yeah, Ayushi.
Ma'am, I don't have any queries because the session was very clarified and it was really very helpful for me as a law student. I have basically studied about women rights and all, but it is good to hear about to the next next mirror of the spectrum, like what all that there should be rights about men also. And like in the Indian penal code we do have sanctions and provisions about women's and their rights and all, and the punishments for them, but there are very less sections about men's, and if they suffer from any kind of harassment or if any kind of sexual harassment and all. So it is like a very clarified uh, thought, and it was like a very clarified way of, like the way you explained with all the case laws and everything. It was really very helpful for me. Thank you so much.
Thank you, Aishi. Thank you so much for the feedback. Yeah, Rachel. I'm finding your hands raised. Yeah, okay. So, yeah, I think, Rachel, if your hands are not raised not by mistake, then we can wind up the call. Okay, I think here we are good to wind up. Thank you everyone for attending, and thank you for sparing your precious 1.5 hours of the Saturday weekend listening to me. Thank you so much. And if you have any queries, if you're not able to ask here, you can get back to the WhatsApp number, or you can mail us so that we can get in touch with you and resolve your queries. And yes, hope to see you in the upcoming sessions. Thank you everyone for attending. Happy weekend.
Thank you. Happy weekend.
Thank you.
Thanks a lot, ma'am.